Welcome to EPG Pathshala. This paper is the philosophy of law. The current module is entitled Ambedkar and Law. The objectives of this module are to understand the Ambedkarite concept of law. This module was written by Arvind Narayan from the Alternative Law Forum, Bangalore. I'm Akash Singh Rathore from Lewis University of Rome. So we all know the basic truism that Dr. Ambedkar is the father of the Constitution, or one of the main architects of the Constitution. We also know he was a great lawyer. But beyond these two vague sorts of truisms relating Ambedkar and the law, do we have any concrete understanding of Ambedkar's concept of law? There hasn't been much work, in fact, to discuss, to put together that Ambedkar had a unique set of ideas about law that can then be extracted to constitute a kind of Ambedkarite philosophy of law. So this module is going to take take up that task. We can understand Ambedkar's concept of law by focusing on three distinct themes. First, the idea of law in Dr. Ambedkar's corpus, in the body of his work, is an understanding of law beyond state law. And this is quite an original conception. We'll get into what this means in the first part of the module. Secondly, the key Ambedkarite conception of law is that law can function as a counter-majoritarian force. So as a counter-majoritarian force, this law can be mobilized on the side of the Dalits, on the side of a minority, against the laws of Hindu society. So to conceive of law as counter-majoritarian is also an original conception, since many definitions of law, you can think of Rousseau and others, sees it as expressly the will of the majority. Thirdly, there are some legal concepts that Dr. Ambedkar introduced into Indian discourse that were missing for 50 years of Indian constitutional history, but have suddenly made reappearance as new forms of oppression unfold. And specifically, I'm referring to the concept of constitutional morality that Dr. Ambedkar put forward, which has recently found expression in Supreme Court cases over the last few years. So what we're going to do is take up each of these innovations of Ambedkar's theory of law or philosophy of law in turn in this module. Let's begin with the first one, law beyond the law of the state. The innovation in Dr. Ambedkar's theory of law is that the notion of law as a command is not limited to the state, but moves beyond what is legitimized by the state to what society sanctions. So let's think about this in some detail. Law as command, where do we get this idea? In the second module on the history of philosophy of law from Austin to Ratz, we discussed John Austin's fundamental contribution to the modern concept of law. John Austin had stated that law is a command issued by the sovereign under threat of sanction that is followed by an obedient community. So we have these extremely important moments in the basic definition of law to which many lawyers continue to hold as the paradigm definition of law. Law is a command issued by a sovereign with the threat of sanctions that people are obedient to. Now, what is Dr. Ambedkar saying? Dr. Ambedkar is saying that this command to which people are obedient because of the threat of sanctions is not only issued by the sovereign, by the state, but rather the sovereign can be understood to be a religious community. So in that sense, law is beyond state law if what everybody in society is following is not necessarily the law of the state, but the law of religious orthodoxy. There's a more detailed discussion of this idea of law beyond state law is undertaken in Dr. Ambedkar's The Annihilation of Caste. Here's a citation from that work. Custom is no small thing as compared to law. It is true that law is enforced by the state through its police, power, and custom, unless it is valid, is not. But in practice, this difference is of no consequence. Custom is enforced by people far more effectively than law is by the state. This is because the compelling force of an organized people is far greater than the compelling force of the state. So now let's move on to the second innovation in Dr. Ambedkar's thinking about law. And this we refer to as law understood as a counter-majoritarian instrument. In the context of majoritarian caste bias, the coercive force of the law needs to be mobilized on the side of right and on the side of morality. Now, interestingly, most theories of what law is assumes that law is in conformity with the majority's custom, practice, mores, understanding. So if we had a system of laws that was perpetually in violation of what the majority wanted, we would have a radically destable society. Consequently, we normally conceive of law as a majoritarian instrument. Dr. Ambedkar's innovation is to suggest that the coercive force of the law, remember the threat of sanctions is always there for law to be law, that this coercive force should be used to manipulate, to educate, to alter the majoritarian will, to alter the majority's conception of what is just, what is moral, and what is right, rather than understanding law as implementing what the majority thinks is just, moral, and right. So as Dr. Ambedkar puts it, sin and immorality cannot become tolerable because a majority is addicted to them or because the majority chooses to practice them. If untouchability is sinful and an immoral custom, then in the view of the depressed classes, it must be destroyed without any hesitation, even if it was acceptable to the majority. So in this passage, Dr. Ambedkar is articulating this expression that majority will, if it is immoral and not in tune with justice, should not become law, and the coercive force of law needs to be deployed in order to alter the majority's conception of what is moral, right, and just. So this is a deeply innovative idea of how the law can be used, and it quite frankly flies in the face of most positivist ideas of law. You can understand more about legal positivism in the early modules in this paper. Now, the form that counter-majoritarian power of the law took during Dr. Ambedkar's lifetime was fundamentally through two specific legal regimes. We're going to discuss these two legal regimes in turn. The first is making untouchability a criminal offense in the Constitution, and the second legal regime is the Protection of Civil Rights Act 1955. So we'll discuss these two legal regimes and see them as examples of the way that Dr. Ambedkar viewed the power, the coercive power of the law as being an anti-majoritarian instrument. So something that the minority could use to alter the morality of the majority. And keep in mind that there's no positivist understanding of law that can tolerate this. So let's discuss the first one. Article 17 of the Indian Constitution reads, under the title Abolition of Untouchability, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So notice this, there's a command, untouchability is abolished. There's a sanction, untouchability is an offense punishable in accordance with law. It's a declaration of the sovereign, of the state, and the question is, will it be followed by the community of the majority? So Dr. Ambedkar's notion here is that we have an anti-majoritarian piece of legislation, and not any piece of legislation. It's built into the fundamental framework of Indian law as Article 17 of the Constitution. That minoritarian interest gets imposed upon the majority and sanctioned through the command and punishment that is a prerogative of the sovereign. So the prerogative of the sovereign is being manipulated by a minority in order to alter the morality and conception of justness of the majority. This is a very unique way to understand how law can operate within society. It doesn't express the general will, it alters the nature of the general will. In a speech in 1930 at the Round Table Conference, Dr. Ambedkar first articulated this idea that would finally be realized as Article 17 of the Constitution. Dr. Ambedkar declared at the Round Table Conference, I quote, "First of all, we want a fundamental right enacted into the Constitution which will declare untouchability to be illegal for all public purposes. We must be emancipated from this social curse before we can at all consent to the Constitution. And secondly, this fundamental right must also invalidate and nullify all such disabilities and all such discriminations as may have been made hitherto." So what's fascinating is to see that Dr. Ambedkar articulates this in 1930 in precisely a counter-majoritarian manner, and it gets taken up almost word for word nearly 17 years later in Article 17 of the Constitution. The second legal regime which exemplifies Dr. Ambedkar's innovative idea that law is not just a majoritarian instrument, but quite to the contrary, can be used to in an anti-majoritarian manner, is the Protection of Civil Rights Act 1955. While recognition in the Constitution of the enforcement of any disability arising out of untouchability was important, so Article 17 is of course of utmost importance, but this constitutional prohibition won't have any impact, won't have any traction unless it finds statutory expression. In other words, something that's stated merely in the Constitution as an article or fundamental right needs to be implemented statutorily as an act of Parliament so that the punishment can be realized. You know, if the Constitution doesn't articulate the mode, manner, and methods of punishment for violating the articles, they mean nothing at all. So every constitutional basic right needs to be translated into a statutory provision, and those statutory provisions then correspond to penal codes, so the manner in which violation of the statutory provision will be punished. So an idea in the Constitution has to take 3 steps before it can be realized as a law by people living under that constitutional regime. The way that Dr. Ambedkar saw to implement this idea in the Constitution was through this Protection of Civil Rights Act 1955. But interestingly, the act was put forward under another name. This bill was moved in Parliament as the Untouchability Offences Bill in 1954. Now, intriguingly, Dr. Ambedkar opposed this title, Untouchability Offences Bill, in 1954. As a consequence, it took another year for this bill actually to become implemented. It became implemented as the Civil Rights Untouchables Protection Act. Now, what's the difference between these two titles? Why was Dr. Ambedkar so concerned about this? Well, Article 17 already shows that the practice of untouchability is widespread and dominant in society. If we're going to move a bill to implement that article, then that bill needs to elevate the idea of what is going on in this prohibition. So Dr. Ambedkar's argument was, if we just have a law that says practicing untouchability is an offense, then people are going to think of the practice of untouchability or the violation of this law as just some kind of police influence on their freedom. In other words, Dr. Ambedkar wanted to elevate the conception of the dismantling of untouchability. This is a question not of a mere religious practice that the police don't allow you to perform. This is a question of people's fundamental civil rights. So he said that if we call this an untouchability offenses bill, it's just going to lead to clashes between police and practitioners of untouchability. If we refer to it as a Civil Rights Protection Act, then people can actually more clearly identify that they are contributing to the nature of a good society by not practicing this, this form of discrimination. Thankfully, Dr. Ambedkar's view prevailed, and this bill finally got passed in 1955 under the title Protection of Civil Rights Act. So even the word untouchability, which Dr. Ambedkar had conceded could belong in the title of act, was ultimately removed. So these considerations about civil rights versus untouchability in specific allow us to see the way that the second innovation of Dr. Ambedkar leads into the third innovation in his unique conception of law. So the third innovation we defined as the legacy of Ambedkar's jurisprudence through terms that he introduced, such as constitutional morality. Prior to Dr. Ambedkar, nobody spoke about constitutional morality in the Constitutional Assembly debates. He introduced this term, and in the process of introducing the Constitution in Parliament, he spoke about constitutional morality at length. There are at least 3 references in Dr. Ambedkar's corpus to the notion of constitutional morality. The most famous reference was in the Constituent Assembly while presenting the draft Constitution. So this idea of constitutional morality is very powerful, and it's been referenced from time to time. But the first time that the concept, as propounded by Dr. Ambedkar, found a contemporary institutional resonance was when it was cited by Justice Shah in his very celebrated decision in the Naz Foundation versus Delhi. In a later module entitled Queering Law, we go into the Naz Foundation decision and see exactly how the idea of constitutional morality plays out. It's worth citing Justice Shah's evocation of this idea of constitutional morality, which he attributes to Dr. Ambedkar. Popular morality or public disapproval of certain acts is not a valid justification for restriction of the fundamental rights under Article 21. Popular morality, as distinct from a constitutional morality derived from constitutional values, is based on shifting and subjecting notions of right and wrong. If there is any type of morality that can pass the test of compelling state interest, it must be constitutional morality and not public morality. This aspect of constitutional morality was strongly insisted upon by Dr. Ambedkar in the Constituent Assembly. So what we see is that in very forceful recent decisions, in this case the Naz Foundation decision, the idea that Dr. Ambedkar put forward of constitutional morality as being the favored morality for India is taken up by Justice Shah. The very moral foundation that makes us want to remove that sodomy is not to be trusted. Public morality doesn't have place in the practice of law. What has place is the higher notion of constitutional morality, which Dr. Ambedkar introduced. So Justice Shah uses this notion of constitutional morality in an attempt to do precisely what Dr. Ambedkar tried to do with the law when he mentioned constitutional morality. That is, use the law as a counter-majoritarian instrument. In the particular case of the Naz Foundation, as you can read about in the later module, Queering Law, the minority in question was the LGBTQ community, which is a very clear minority within the overall population of India. But the laws that are implemented, for example, the sodomy laws, make it a criminal offense to engage in certain private practices that are consensual. So Justice Shah evokes constitutional morality in a manner that allows us to see that the majority's opinion should not tyrannize minorities' access to civil rights. In this respect, the second innovation of Dr. Ambedkar is intimately tied up to the third innovation, which is the introduction of a term like constitutional morality. To sum up, we've discussed three innovations of Dr. Ambedkar that are peculiar understandings of the law. So moving well beyond the truism that we all have that Dr. Ambedkar is the chief architect of the Constitution and that he was a brilliantly educated lawyer, we find in fact that Dr. Ambedkar had substantive, innovative conceptions of jurisprudence, not only that were introduced into the Constitution and subsequent later statutory provisions, but that also continue to inspire judicial understanding today, such as that we witnessed in the Nas Foundation case by Justice Shaw. In Dr. Ambedkar's writing, one finds a clue that to achieve change, one needs to challenge the prejudices in the inner world. In other words, the intimacy of one's beliefs. But this inner world is beyond the reach of the law. The law can't regulate what you think, what you believe. It can only get implemented at the moment that you start to exercise or realize those beliefs through practice and action. But it is the ground for righteous law which, working together, would bring about the possibility of a just society in Dr. Ambedkar's understanding. So by reinterpreting what the meaning or significance of those actions are through law and through discussions beyond law, we can finally attempt to elevate people's beliefs. And that was one of the fundamental teachings of Dr. Ambedkar's understanding of jurisprudence. Thank you.